In this video we're going to look at how to sue a company in small claims court so you can get back the money that you believe you're owed. So first thing, we need to get through a very quick disclaimer. This is not legal advice. We're only looking at general principles, so look up the specific laws in your jurisdiction and you must do your own research on top of this. This is just very general overview. So we're going to go step by step. The first step is you must attempt to resolve. So before you go to court, you want to be able to produce evidence that you've actually attempted to come to some sort of resolution with the company. And the way you do this is you write a very formal letter or email, state exactly what your complaint is about, set out the legal reasons that you believe that you're right. Ideally you'll be citing some sort of laws, case law if you really do your work, and clearly set out that you think you're right and they're wrong. Look as professional and as aware of your rights as you can. Take it very seriously, and if they can see seriousness, it may make them more interested in settling with you. And clearly state what the settlement is you want. You want to have a nice calculation showing where the number comes from. They won't just pay up any old number. They want to actually understand what they're paying and why. And clearly state that if a resolution cannot be found by, and put down a date that you'll take court action against them, but be careful not to be harassing in how you do it. Second step, consider whether it's worth it. You could lose the case, so that means losing your costs. So think in terms of odds. If it's 10 to 1 that you'll win the case and you're spending £50 to bring the case, you ought to be winning over 500 for that lawsuit to make any sense. You have to pay the court fees to start with. You'll not get a lawyer or any other legal costs that you run up back. You may get the court fees back, but lawyers are not allowed in small claims, though you may consult with a lawyer to help you build your case, but they can't actually argue the case on your behalf. There is a limit in small claims court. If it's over the limit, like £1 million, you can't use small claims, and if the case is too complicated, it could be allocated to another track, and you'll have all the other problems of not being in the small claims court. So if it's too complicated, small claims is probably not where it belongs, and it will cost a lot more to bring. Third step is to actually prepare your case. You ought to be looking at legal principles, and we'll look at unfair terms and consumer contracts laws because that's probably of relevance to most people watching this. If you really want to do your work, find the case law. If you can say to a judge, here's this obscure case that is exactly the same as what my problem is, that are hard to find. If you find one and say, this is how a judge ruled in the past, it's almost identical to mine, that really helps the judge to see that you're right. So if you put in the work and find the case law, that helps a lot. Get a basic textbook. It doesn't have to be the expensive brand new edition, though that's slightly preferable. But basic principles of contract law don't really change all that much. So an older textbook is fine. edX and YouTube are also good ways to learn about law as you're doing now. Ask yourself, if you try to profit, if you're bringing the case to make more money than your damages, you're probably not going to win that part of it. You should only be looking to get back what you've lost. You've got a duty to mitigate. For example, if a builder left a hole in your house and you left it for 3 years and your house fell down, don't sue for the falling down of the house, because that was partially your fault for leaving it 2 years. You've got a duty to mitigate your losses. Terms that are unfair. In the UK we have the Consumer Rights Act. I've plucked out a few of the key ones. In other jurisdictions, particularly America, there's laws to the same sort of effect. Terms and conditions don't always stand. You're not completely bound by them in consumer contracts. Terms that exclude legal rights. If it says you can't bring a lawsuit, that's not going to be held. Unilateral, what they call unilateral contract alterations. So if one party, the company says that they can change the contract however they like, that's not going to stand. Automatic contract extension. If you have a year contract and you keep paying after that, you're not going to be bound by the year contract unless you've taken out a new contract. And termination without a valid cause basically means the company can't just declare the contract at an end for any reason. There has to be a valid reason for that. For example, you haven't been paying your bills. Next step, you need to gather all your evidence. The company can't withhold evidence. That's a good part of the law to be aware of. You can turn the screws if they're refusing to give you information. They have to hand it over with few limitations. So if it's required to bring the case, they have to let you know that. Account statements to prove that you actually did pay or lose the money. The response to the company, the response to your complaint will basically set out why they're not going to pay. The judge will want to see that. Bring the contract, show the evidence of the breach, witnesses if relevant. Expert statements go a very long way. If you had a dispute over a computer, you could bring in a repair shop owner to say, yes, the computer is clearly no good, or this is the problem. That can be helpful. Calculation of the damages, show exactly where all the damages come from and why. Get quotes, preferably multiple. It shows that you're being fair and mitigating your losses by going to the lowest cost for example, repairing your car. Useful terms that you'll want to know: anticipatory breach is where the contract hasn't been broken yet, but is almost certain to, or has already been stated that it won't fulfill the obligations in the future. Specific performance is where you're requiring a company to actually do something rather than just pay you money. Rescission is essentially, how do I explain this very simply? It's the kind of unwinding of a transaction or a contract. It's in very simple terms terminating, stopping a contract, bringing people back to the status quo. Then you've got void and voidable. You'll see this a lot in your research. A void contract's a contract that never existed, and if the contract never existed, you're not bound by it. So anything that happens under the contract, well, if it's void, it doesn't matter. Voidable is where a contract was a real legal contract, but for some reason it has ceased to have its effect on one party or for some other reason. Then you've got contract frustration. That's a change in circumstances that makes a contract impossible. Statute of limitation, or the limitation period, is a limit on how long you can wait before bringing a case. For example, in certain cases, if you don't bring them within 6 years, you can't bring them at all. It's gone. That your right to sue is expired. Next step is to lodge a claim. It is absolutely important, key, that you make sure that the defendant is served properly. They must know that they're being sued. If you can't show that they've been informed that the case exists, that you have no hope that your case will just be stopped. They must be served. It must be clear that they have been served. They may or may not submit a defence. Generally, big companies can't be bothered. Small companies probably will. Right. Next step, going to court. Respect the formalities. Conservative dress. You have respect for the proceedings, Your Honour, that sort of thing. Get straight to the point. Limited time. Set out your case clearly. Practice it. Get straight there. No rambling stories. They're not interested. Be professional. Be honest. If you're dishonest, it seriously harms your case, because if you tell something that's slightly implausible but true, it's probably not going to be believed, even if it is. And be as fair as possible. Don't try and get more than your due. That puts a judge in a more sceptical mind frame towards your integrity. Evidence, bring 3 copies, one for the judge, one for the defendant, one for you. Potentially 3 people looking at it. Just bringing 3 copies makes life easier. Last step is to enforce the contract. Reputable companies with a court ruling against them will almost always pay up. It's not worth their while going through all the appeals. They'll just pay it. They've lost. They'll move on. Enforcement agents, if you can't enforce it, they're the people that can enforce it for you. It's a lot of hassle. You do have the right to charge interest at a certain rate that's set by the court, and you can recover or levy the enforcement costs against the company. But the last thing is, you have to consider, can the company actually pay it? Companies House Search in the UK will let you see, to some extent, the accounts of the company. If it's been losing money for 10 years and is close to bankruptcy, there's probably no point even bringing the case, and you're not going to enforce it. A lot of judgments do go unpaid, even if they go with you. So hopefully this information gives you the basics to bring your case, and I wish you the best of luck. Thank you very much for watching.